The way we cheers has really shifted lately.
It really has.
We'll get back to the good old days.
Welcome back to me. It's been a while since I've been here. I was on vacation, so...
How was the vacation?
Oh, it was fantastic. I've got pictures on Facebook.
That is outstanding.
I know. But we wanted to talk a little bit more about how things... Because we've had a number of applications that the longer it's been since we talked about it, the more applications we got under our belt. So we want to talk about some new legislation that a lot of people think is unfair to the accused person. But there's a lot of reasons to actually take lemons and make lemonade, right?
Yeah, so, this may seem like a deja vu to some of our viewers, but we spoke multiple times about, Bill C-51, which brought in this new regime, and I love saying the word regime.
I know you
where
did.
the defense had to make disclosure of messages and records and pictures and all sorts of things in their possession. And at the time, I thought the sky was falling. It's the end of criminal justice as we know it. Where on earth do you have to disclose defense evidence, aside from possibly an alibi? This is absurd. It's catastrophic, all those terms. Now, like several years later, and we're 21, 22 applications in now, something like that. Yeah, it's kind of, it's worked out. And I think we should probably just remind people about the legislation, some of the new law, but then talk about some of the real advantages that we've seen now.
Well, first of all, prior to this legislation, a lot of people would do these pretrial applications, mostly with evidence that had to do with the sexual nature, evidence of the sexual nature. But there was kind of a form you could fill out, and it was really bare bones, the way these applications are mostly filled out.
Yeah, so there's always been Section 276 under the Criminal Code that said that any evidence of a prior sexual act for which you want to ask questions about was barred if it went to the twin myths. And that was, pretty straightforward, understandable legislation, and you brought an application, and the threshold wasn't that high, and everything made sense back then. And then they amended it to say other sexual activity, so not just prior sexual activity. And
that's very, it's interpreted very differently. So that can include flirting for some judges, whereas for other judges, that just, no, we're only talking about actual physical acts of kissing or,
hand-holding.
Hand-holding, yeah. Don't forget that one.
But it's different for every judge what that phrase of a sexual nature means.
And parsing it out. So we never had an issue before when we wanted to say people got together for an evening. And so they might have been talking, and then one thing led to another, and then they were kissing and holding hands. And then it stopped, and then they went to have a drink or did something. Then they wound up kissing and holding hands, and then it moved into a bedroom. But then the world went a bit crazy because certain judges would say, oh, no. The hand-holding and kissing that happened an hour and a half ago, that's a totally separate incident. That's other sexual activity. That's not admissible. So they'd parse it in very crazy ways, whereas we'd see it as one flow of a transaction.
I know, and that's one of the problems is that, was it fluid or, at what point do you say there's too much of a break in time for it to be part of the transaction? So what do? We assume err on the side of caution. Everything goes in to these applications.
Yeah, so that's a good point. So that's a good starting point. So, because of the amendment to Section 276 and some of the position of judges that we've received, we just don't take a chance on it. We will include things that we would normally have said is part of the transaction or part of the evening, and we just include it in the application because we don't want the grief, and we lay it out, and we'll talk about it later, but that helps with our narrative anyways. It doesn't really hurt. But that's some of the craziness. Like, you'd think about an hour before they're kissing or they're talking and holding hands and flirting. Somehow that's other sexual history, but it is. We've gotten accustomed to it, so it's not such a big deal. But, the bigger issue, which was the amendments, which created these new sections, 278.92 and 278.94 of the Criminal Code, it was a big deal. And then the Supreme Court of Canada in JJ held this legislation to be constitutional, and there were a number of important things that came out of JJ. But basically, we take the position that any and all material that you have related to the complainant all the messaging, all the pictures, all the things that maybe even are in social media and posted that may be of a mundane or public nature, we even include because we just don't want to take the chance. All of that has to be disclosed, has to be vetted through a judge, and if found to be a record, we'll go to the complainant's lawyer. So that's the regime we're talking about.
Right.
So what's the good news?
Well, the good news is that, a lot of defense lawyers have been really skeptical of using this legislation, and they try to withhold as much as possible. We found the opposite, that when you lay out the accusation in full, and we have, a well-crafted and presented anticipated evidence of what we expect our person to testify to, that you can lay out the foundations in a much more effective way. And there's a couple of notes for that too. It's very important to accurately summarize, even if it sounds bad, to accurately summarize what the complainant has said. It's very important to be accurate with that. So otherwise, you're going to be challenged. Oh, that's not really what she said.
You have to have credibility.
He or she.
Yes.
Yeah. Mm-hmm. And then the anticipated evidence, I think, is where it gets into a little more, cautious territory in terms of, and maybe Michael, you want to weigh in on this?
No, I was just going to say, why is that?
Because it's essentially the equivalent of giving a police statement.
And right? Reverse disclosure almost. Right?
It is.
It is reverse disclosure.
It forces us. So in the application, in order to ground the relevance, we have to put forward, to some extent, what the defense position is. Now, JJ says, you don't even necessarily have to put in an affidavit on stage one to see if it's relevant.
From the accused person. Right. They said anybody.
Could be from anybody. And then when you do, let's say you go on a stage two, put in an affidavit, just has to be enough to sort of give a description of what the defense may be and how it's relevant. Yeah, that's not really real. That's bullshit. You really have to lay it out. So in essence, what you have to do is very carefully analyze the case much earlier on and be very careful about how you lay out your anticipated evidence, both in the application and in the affidavit. It forces you to do that. If you don't do that accurately, it can come back and bite you in the ass, particularly because on the application, the Crown, not the complainant's counsel, but the Crown has the right to cross-examine on that affidavit. That evidence is admissible at trial.
And normally the accused has to be the one to put in the affidavit because they're the only one who can verify that certain documents are accurate and true.
I'm sure people are already thinking this. How many times have you had the accused cross-examined on the affidavit at that stage?
Twice.
I was thinking about half the time.
No, I think it's twice.
Well,
maybe 3 times.
There's a certain prosetter who wants to cross-examine before they're even permitted, right?
But out of the 21 or 22, I think we've had maybe 4 or 5 times, but it sort of died off a little bit.
It's not exciting anymore for the Crown.
No, they got really excited at the beginning, like, this is great, and then they realized it's not working out so well, and it's kind of died off a little bit. But I just want to back up for 1 second. So we lay out all the records, but the other thing that we do is, what about records that the complainant turns over to the police that goes to the Crown? So let's say messaging, and some of that can be selective messaging. We always talk about how they don't give the complete picture, but it goes over to the Crown. JJ says if it's production from the Crown as part of their disclosure, you don't have to vet it through this regime. But have you found that to be true, Mr. Burry?
Absolutely not.
Oh, tell us about your interesting recent experience.
Well, I had a case where it was disclosed to me, and then the Crown said, oops-a-daisy, we made a boo-boo. That was a mistake. We didn't get...
What was disclosed?
Text messages. Text messages between the complainant and the accused.
How many?
Several.
A lot.
Lots.
Lots.
Yeah, lots.
And were they redacted?
Yes.
Explain what that means to everybody.
Redacted means... This is almost like Sesame Street.
Yeah,
redacted
slowly.
means someone has sat down with these, got the big black magic marker, or in Adobe, the redaction function, and X stuffed. Well,
I got to renew our Adobe.
I know you better, because
Okay.
and blacked out stuff. So someone's made the conscious effort to review, redact, and release.
Who normally
sounds
does
like
that in
Eat,
the Crown's
Pray, Love
office?
or something. What?
That's right. Who normally does that in the Crown's office?
Typically a seasoned disclosure clerk, or sometimes a Crown, depending on the importance of the case.
Wow. So that means that if you were to receive messages that have certain things blacked out, you could presume that somebody had applied their mind to it to remove things that might not be relevant or prejudicial, and then consciously disclose what would be proper disclosure.
Right.
But
again, the Crown said, oops-a-daisy, this was a big accident. We take it back.
it's not a f***ing joke.
It's not.
This was like literally, and this only occurred at stage 1 of the motion.
Right.
So applications filed well in advance. Both of you worked on the application. So 100% detailed, completely laid out, great advocacy.
Not only were they disclosed by the complainant, but the complainant referenced the messages in the statement.
Right.
So so it wasn't just the messages themselves. It became a part of the complainant's entire narrative of what was going on that night.
Right.
So add that to the mix.
Right.
That's great. Yeah. So she referred to it. It became part of her narrative in her statement to police, which is the base upon which the police lay the charges. Right. The messages are then disclosed. You guys draft...
Not the complainant, which you would think she's giving them because she thinks these are important for the investigation, right?
Right.
Which would be seen as, by most people, would be seen as a waiver of her privacy rights.
Which is supposed to be seen as a waiver. JJ says that, right? And you file a detailed application setting out the entire defense. That's filed. There's no written reply?
There was. I think she started fetching at that point.
It was a small
Yeah.
Get to stage 1, and that's when they say for the first time, that was unintended disclosure.
Yeah. She didn't waive her privacy rights. That was a oops-a-daisy.
Again, not a joke. That's why we're circling back to this. So the reality is, and we've come to this habit, that if we get it in disclosure, we include it.
Well, I think part of the reason why these decisions get made after seeing the application is because the prosecutors do start to, and this is one of the intentions, they do start to rethink about what their prospects of conviction are.
Right. And so if you want to take back bad evidence for you, you're not really judiciously doing that review of reasonable prospect of conviction, because you're not supposed to take back evidence that doesn't support your theory as a prosecution.
Small summary point. So if we get it from the Crown, just so people get it, doesn't form part of the doesn't have to form part of the application.
According to JJ, it should not.
We get
because
it.
It's taken as a waiver of privacy.
That's right. And
it's a product of the investigation as well, which is specifically excluded from what would be determined to be a record subject to an expectation of privacy.
So the whole regime doesn't apply, just so people get it. With those with those documents, with those text messages, we can go crazy. Right?
Should be.
Okay.
But
yeah, like how we did that at the same time. It's like
you can't really rely.
Butt.
You can't really
and
rely
it's a
on
big butt.
that. And then often we found that the Crown is not necessarily sometimes thinking about how the evidence actually calls into question other inadmissible evidence, other discreditable conduct, which is something you have to bring a separate application for. So what we've decided to do, and we do it now more, is we just include everything. So it's Crown disclosure, we include it. If we think there's bad character evidence in it or discreditable conduct evidence, we put it in there and we flag it for them.
Right.
It's like paint by numbers for everybody, right?
That's important too, because the Crown doesn't always bring an application for bad character evidence, even though the statements of the complainants will be replete with it.
They're thinking we won't notice.
And let's break that down for 1 second. So in days old, it used to be on anything
also
that was...
known as olden days.
In days old...
He likes to say that.
In dinosaur days, when there was a domestic-related offense, but it includes, in our case, it's sexual assault, bad character evidence used to be referred to as, well, that's just context evidence with respect to the dynamic
context and narrative
of the relationship that assists with understanding why the complaint did or did not do certain things. Okay? So it went in. Then the law shifted to say, no, too much is coming in under that. You have to bring a application, Crown, if you want to call this other discreditable conduct evidence, and you have to justify it. So that's where we are now today. The problem is that happens rarely. Like, we have to remind them to bring the application.
Right. And it's sometimes an issue too, whether or not they can contain that type of evidence. If they say, because if you get certain kinds of, this always happened or this never happened, I would never agree to this, then it opens them up to cross-examination on those precise points. So it's not always in the Crown's best interest to put that evidence in. That's why it's important to think about first. Because for fairness of trial, You can't allow one side of a narrative to come out and then not allow the other person to cross-examine on that exact same narrative.
So we've erred on the side of caution now, where we just literally lay absolutely everything out, no matter what.
So
Holus bolus.
explain this to our viewers. So my client just dumped on me a shared folder which must have hundreds of different flavors of documents, text messages, photographs, a little bit more explicit photographs, just everything.
Yeah.
What do you say to your client? What do we got?
Well, you say to them, give me everything.
Right.
Let's assess its relevance, because we have to be careful. Is there some evidence that's really not relevant, or is it too gratuitous? Right? Is it over the top? Diana?
Well, this is also a reason why it's important that the accused version of events is included in the application, because sometimes their evidence is relevant to rebut something a complainant says, but sometimes it's relevant to support something they're going to testify to. So it's not just one side of the story you're addressing at that point, that their evidence will become relative, and at the initial stage prior to trial, that it should be taken at its highest that the applicant's version of events may be true.
And so that's important. So part of what we're doing when we do these applications is we're storytelling. We're telling a story and laying out in a very detailed manner the defense. And evidence that would be admissible is not just restricted to contradicting or rebutting what the complainant says by way of their narrative, but also it may be relevant to the coherence of the evidence of the accused when they testify.
Right. And that's so important to remember, because we've talked about this before too. There is a presumption of innocence. And there should be.
What?
There should be, just like they say, like, oh, we #believe complainants. We should be going into this, especially before the trial is actually officially taking place, assuming that maybe the applicant is innocent. Maybe the accused person is telling the truth. And that's, I think, a very important aspect of these applications that sometimes prosecutors forget as well, because we've seen quite often they'll say, well, that doesn't matter because the complainant said this. And I said, well, the complainant can say that at trial, but in this application, our guy is saying this, and if he's telling the truth, this evidence can support his version of events. That has some value to it.
Tremendous value.
Yeah.
So a lot of people might be scratching their heads thinking back to Ghomeshi. What was different about the Ghomeshi trial versus what you're talking about now?
That was the one that started this. I mean, that's the good old days. Yeah, I know. So, the Ghomeshi case was when, Marie and her team had in possession
tons
voluminous communications between the complainants and Mr. Ghomeshi, which undermined their narrative.
Mm-hmm.
As well as they managed to get a third-party records application with communications between two of the main complainants.
Right, but one would imagine, the Crown would have been knowledgeable about that at the time of the third-party records application. But they had a plethora of records completely undermining the complainants and also showing collusion. Right. So you would cross-examine and you'd say, did you not on Monday after the date say, thank you very much for the date, it was amazing, X, Y, and Z. I didn't say that. Are you sure you didn't say that? Like, that was the good old days, right? And the whole bullshit that came out of that is somehow that they're
being
ambushed.
blindsided or ambushed. Yeah. And I remember we did a panel discussion on the new legislation and specifically the Ghomeshi case, and I think I made a really good point. I remember you turning around, because we just recently met at that point. And he was like, what a good point. It was like, it doesn't matter, because one of our panelists said, well, how are they supposed to remember what they emailed? And I was like, it doesn't matter if they remember it. It's an accurate capture of what they were actually thinking at the time.
How the is the accused supposed to remember what he did or said 30 years before when a charge comes out decades later? Nobody gives a shit about their memory or how they're supposed to muster a defense. Why is it our job to remind a complainant about shit that they said that's truthful and real-time evidence of really what the dynamic was? Why is it our job to help them?
And jump through all those hoops.
That's what our argument was. And we're still of that view that really, when you think about it, like, no, we shouldn't have to do that. But it hasn't worked against us so much.
Yeah, and to be fair with the new legislation, it was pointed out, and it is true, that if they make certain statements and then they change their evidence from the time they made the statement after the application to when they testify in court, be like, you're aware of the application that took place, right? So you can confront them with changing their evidence based on what they were most likely made aware of during the application.
And under JJ at stage 1, if the documents are ruled to be records and you go to stage 2, or they're ruled to be admissible, because they have to be admissible as well, the judge can limit what's allowed to go to the complainant or complainant's counsel, so there can be redactions. And generally we found complainant's counsel to be very judicious about what they actually do disclose sufficient to get instructions.
Yeah.
I mean, they've acted really quite reasonably.
Tell me something, because Yuvi was asking me this the other day. There are no rules with respect to complainant's counsel and what she can or he can disclose to the complainant, are there?
We can't know what was disclosed.
It's not ruled out in JJ, but what is not used enough, and we haven't worried about it, to be honest, because I frankly don't give a shit, because when complainants change their evidence, it just gives us more to cross-examine on, and then...
And you're good at that.
Well, thank you. But, it's just like, well, that's exciting. Well, tell me how'd you come up with that excuse for your for that particular message. Let's read the English. Yeah. I'd love to have sex with you. That was a great time. Thank you. And now you're saying, no, that was him pressuring me to say that. Or something stupid like that, right? We haven't cared about it that much. But you can, at stage 1, when the ruling is made, they're records and they are admissible, say, based upon these submissions, I'm asking that only this much goes to complainant's counsel and should only be this much to be disclosed to the complainant. You can do that. It's
That's
underused.
good to know. Yeah, I think so. I haven't heard many people using that.
Because there's not the rulings. The part of the problem is we don't get the rulings. Like, there's lots of rulings, but they're not really on the database in Quick Law or Canley or whatever. And so you don't have that type of guidance.
They were at the beginning before we got the ruling from Supreme Court, because the judges...
Everybody was trying to figure it out.
We're trying to share their rulings to help other judges figure out what to do. Yeah. But now that we have the Supreme Court ruling, it's very rare to see them published.
Let's just say one thing. So people may be wondering, how do you determine what is a record? So the test actually is, it's something... If a record relates to the complainant, contains personal information for which there's a reasonable expectation of privacy. If the record contains sexual activity, then of course it's subject to the regime. So the exception used to be previously as well that if it was about the subject matter of the offense,
directly related to the
allegations, it's not subject to this type of regime. We're not clear on JJ that really applies anymore. We see that if it's a record, it's not clear to me that we can get away with holding it back.
No, because what they said is that it may not be covered by 276 because it's subject matter of the charge, but it may still have too much prejudicial effect or privacy invasion that it's not justified for the probative value, right? So the value of the evidence is not overcome by what would be seen as like humiliation or embarrassment to the complainant.
Have you ever had a case where this pops up in the middle of a trial?
That's a very good point.
I try.
We have, Diana.
Yes, I know. So we have to bring these applications
normally pre-trial. But
before
let's say
trial,
you don't, and it comes up during trial.
Well, in which case you're guessing as to, based on mostly the police statement, as to what's going to be said, but we haven't actually had the trial evidence yet. Mm-hmm. So sometimes the complainant will go totally off script of what they were saying before. They might throw out new information that in one of the cases, I'm sure that's the one you're thinking of, the prosecutor was even going, what?
Where'd that come from? Yeah.
They had to go off and run and look for new stuff that they might have been missing. And so stuff can come up mid-trial that will then allow you, and you can reopen an application. So if you fail even in part on an application, but then something happens during trial, you can reopen it.
Just so people know that. It's important.
Or you can bring an application you didn't know you needed because of something that's said during evidence at trial. So it's not completely like
etched in stone.
A crap show at the beginning, that it can be revisited. And we in fact did bring up, because some of the testimony that came out was completely unexpected, and there were certain things we thought were going to be conceded, everybody would have thought would be conceded, that then were challenged by the complainant during the testimony. So and we were successful, at which point the Crown actually withdrew the charges.
Yeah, it's a rare... Well, it's because she refused to come back for cross-examination.
I know,
a problem too.
She knew she was screwed.
But, there are instances where you may have records, and for some strategic purpose, you don't think it's really relevant until, or you should bring the application until the evidence has gone in through the Crown, or even partway through cross, and then you can stop and bring a mid-trial application. If you're before a jury, that really could create a mistrial, so that's not something you want to necessarily do. But in a judge-alone trial,
Really?
you can, and it's happened to us.
Aren't you going to have a judge say, "Hey, come on, that's a bit greasy. You knew you should have known and brought this pretrial."
Well, you can be subject to quite a bit of a smacking around on that, but you can still do it.
Yeah, nothing prevents
Like the
it.
Supreme Court says, err on the side of caution in
Right.
advance, right?
Yeah, and they can say, like, the Supreme Court told you, but you can't. But we don't. We say you really shouldn't do that.
Right.
But there are instances, which is in our case, and frankly, this was because we had other evidence that we thought was gratuitous. We thought it's just too much. Yeah. This is like too embarrassing for
Well,
the
you have to
complainant.
justify it, that you're not just trying to humiliate the person.
Yeah,
Right.
And we applied our minds to that and said, this is too much.
Yeah.
It's too much. We're not going to do it. And the client was going, no, you should do it. And we're like, no, we're not going to do it. We're officers of the court. This is too much. We've got a lot more reliable information. But then,
Offside she went.
offside in cross-examination, completely disagreed with stuff that we thought, what the f***? Like, it's like you're saying the earth doesn't rotate.
Right.
But I think this is a really important point to make as well, because there's so much criticism of defense lawyers that we're somehow abusive of complainants. And the fact that we're actually
Tell me about
restraining
it.
ourselves in these applications, and
People
we do
have no
turn our
idea, yeah.
minds. We do turn our minds to what can we justify and what is just gratuitous.
Right.
And if you try to go scorched earth and gratuitous, you're
Not gonna
going
get very
to
far.
not do well.
No.
Right? And I think that there's a real misunderstanding about the fairness of what's going on, which leads me to another point. I think
Let me just say one thing. Most defense lawyers who practice in this area, sexual assault, because it really is, a subspecialty now that you really have to practice to know how to do it properly, do pay attention to the guidance from the courts and do not necessarily want to overplay a hand with gratuitous information to humiliate a witness or a complainant. It will not benefit you.
It'll backfire.
And they do take that judgment very seriously. I'm sorry, it was leading into another point.
Well, and I think this is maybe a good point to kind of finish off, and everybody, I'm sure, has their own views on this. But I think it's generally agreed that the purpose of this new legislation was to obtain more convictions. Right?
What did JJ say at the beginning? We must do more.
We must do better, yeah. And but I wanted to ask you your thoughts on is there's this whole concept that's been out there and part of the crafting of this legislation that we need to balance the rights of an accused, which is the right to a fair trial, with the rights of complainants, which they quite often like to call victims in advance.
They call them always victims, yeah.
So that they
I think
want
they
to
have a rights
balance the
bill.
rights of a person's right to a fair trial with the privacy rights of complainants. So how do you think this is playing out? What do you make of this idea of balancing rights?
I understand, because we've all seen it, that there have been cross-examinations that were improper. We've seen it. And in the old days, lawyers would get away with it. But I found that it was counterproductive, wasn't pleasant to do, and didn't necessarily help your case. You may incidentally get an acquittal, but not because you had an overly invasive and embarrassing cross-examination. But it happened. So I get the idea that there has to be fairness to a witness or a victim, as they want to call it in the legislation. I understand that. But we regard them as complainants because there's presumption of innocence. These allegations need to be tested, under the crucible of, a trial, which is the key part is cross-examination. And yes, we're balancing the right to some dignity and civility and privacy, but that can never outweigh the rights of an accused where their liberty is at stake. And liberty is really just, it's just one aspect. Being charged with this offense is life-altering. Being acquitted, your life is still life-altered. These charges are extremely serious. And so we can't lose sight of the fact that this is life-altering. And a conviction will result in devastating consequences for an accused. So I think you'd agree with me that what we've seen, the courts are doing a better job than we thought, striking a balance, but keeping in mind that that liberty is at the heart of our considerations, that is extremely important. That's why we quote Nisnik now in our written submissions almost at the beginning, because there was a very apt decision with a number of very good paragraphs by Her Honor that we think is very important and at play here.
What does Nisnik say? Tell people.
Well, essentially it says a trial is not about, I wish I could directly quote it now. But
just summarize it.
Said, she talked about the Me Too, because the Me Too movement was really prevalent at the time. And she said, hashtag believe is not a legal principle, nor should it ever be.
And it's not, a trial isn't about, a vindication of a complainant's allegation. Right. It's a trial based upon principles, the presumption of innocent, proof beyond a reasonable doubt, that we must hold dear to these principles. We must still be careful about wrongful convictions. It says all the right things and tries to explain to the, observer that there are other issues and principles at play here. So I just think it strikes a very good balance, and hopefully it explains to what would be complainants as well as to the public why we have to be so careful in these trials.
Well, for Michael, there's, you maybe address this as well, there's a phrase that we use quite often because it's case law, that an accused has the right to a fair trial but not to a perfect trial. Right. That has the most advantageous aspects to them. So why is that?
It's just how these things play out, right? The accused should have almost a perfect trial at all times, I think. As best as we can do,
That's
right?
the balancing of rights.
That's the balancing, right?
Right? I got to say, I think that's a bit of a throwaway phrase. Like, I think they're not entitled to a perfect trial. No. You can't have a perfect trial. Right. Like, you just can't. This is an exercise in human behavior and psychology and dynamics. It's not a scientific analysis or question or study. So you can't have a perfect trial. I think, though, on balance, that the courts try and err on the side of giving as fair a trial to an accused as possible where it is properly laid out.
Well, and I guess that's another thing about the applications and what we do as well. We're very careful to explain to the judge why it is we're seeking to use this evidence so that they understand we're not looking to attack the character unnecessarily. It goes to a direct, relevant issue at trial. And it is so important to do that because even though something could be used to perpetuate some sort of rape myth, it doesn't mean that's how it's being used.
We're not out to assassinate character.
So
right?
It's important, and that's part of the art of what we've learned to do, and why it is, as you say, a subspecialty of people who understand the legislation and what's required in these cases to really be clear, because that's the whole point of the application. You have to make it perfectly clear what it is you expect the evidence to advance at trial and what it is you are not wanting it to be used for in terms of some sort of myth or stereotype.
Yeah, and it's really changed. I mean, it's a big shift in dynamic and sort of a paradigm for defense lawyers, because you are literally laying out your case, and it's written advocacy, which we've never done up front, unless in charter litigation and stuff like that. So it really is extremely detailed that way, and you have no choice, and it's the smartest way to go about it. And I think it does work out in the end. But I do think, when it comes to trying to balance the rights, it's good. I think these are difficult cases, but I've been cautiously optimistic now.
We do it with decency. That's the bottom line.
Well, we do it well.
We do it well.
Yeah.
We do
Okay,
it
well, let's end on that.
Yeah. And we always say, get it right the first time.
Right.
Well, hang on. We're not going away. You know what? You're right, because
you don't want to have to pay for an appeal.
Call us for the appeal.
No, but you know what? Let's just say this for 1 second, closing out this one, because I'm probably going to say it in another one too. When you lay out these applications, what are you contemplating doing at trial? What's going to be a big part of your defense?
Calling your client.
Calling your client to testify.
I heard the whisper.
Right? Calling your client to testify. I can count on one hand. I've said this a number of times. Maybe in 5 cases I've done, I've never called my client. The majority of them, I've absolutely called my client.
You almost always have to.
You have no choice.
How can you not?
So, like, that's just an important part of this, and why I think this written advocacy sort of helps us. Okay, now we can click.
Now we can reclaim.
Okay,
Yeah,
we'll
sorry,
reclaim.
sorry about that.
It's a reclaim.
So thank you very much, everybody, for watching. Keep sending in the questions and comments.
Get the pillow.
If you like, if you
Yeah,
like
we need one. We can
what
pass
you're
it around.
seeing,
Yeah, pass
like,
the
share,
pass around.
subscribe. They're f***ing around with the pillow.
I beg
so
your pardon.
Like, share, subscribe, hit notification. Have a good night, and thank you, everybody.
The pillow survived.